Hello, welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a criminal defense and firearms lawyer, and today I want to talk about the case of the Queen and Zora. Now, this case on its face is just a case about the mental fault element for a breach of bail conditions. And what I mean by mental fault is that in Canadian law, you need to have two elements, and each of these may have separate sub-elements to prove the offense. That's the actus reus and the mens rea. So the actus reus, which means guilty act, is the actual action that was taken. So if we picture a theft, somebody walking out of a store with items that they haven't paid for in their bag, that would count as the actus reus. Now, in terms of the mens rea, you have to be aware that those items are there. You have to have intended to do this in some fashion. So if we can think of some examples, like you're walking around in the store with your bag open and a prankster throws an item in there, but you don't know it's there, they wouldn't be able to prove the mens rea element because you weren't aware of that item that you were walking out with, and so they couldn't convict you of the theft. Similarly, if we picture a situation where you've got an item in your bag and somebody physically picks you up and takes you out of the store, you probably didn't have the mens rea requirement for that. Or if you have something and you put it away and you're planning to pay for it, and then you just forget about it for some reason. So all of these are situations where you may not have the mental fault requirement in order to be convicted. And now mens rea falls into two separate categories or two types that we'll see. The first is subjective mens rea, and that applies, what that means is it applies as you are. So it's to what was actually going on in your head. Now, objective mens rea applies more of a reasonable person standard. So it's what should you have been doing? And where this distinction comes in is we use objective mens rea for situations where there's some sort of duty that gets imposed. So a clear example on this would be careless storage of a firearm. You're required to follow certain standards on that. Those standards need to be sort of uniform across the board. And it's up to you to live up to the standard of the reasonable person. But other offenses, many other offenses, require just a consideration of what was actually going on in your head. Now, why this matters to Mr. Zora is that he was put on curfew bail conditions. And so what that means is that during certain hours, he's required to remain in his home. But also there's a separate condition that requires that during those hours that he's supposed to be in his home, if a police officer or other person who's designated for this purpose knocks on the door to check on the curfew, he was supposed to show himself at the door within 5 minutes. And so they put this condition on so that we can check that somebody's actually following their curfew. Without a condition like that, the only way you can tell somebody's actually not following their curfew is if you find them out doing something. Typically that means that they get found committing some other criminal offense. So the circumstance that Zora found himself in was that an officer had knocked on the door on a couple of different occasions and not gotten a response. So the officer concluded that Mr. Zora wasn't home. The problem with this is that Mr. Zora later testified that he was in fact at home, and that the circumstances there were that he just couldn't hear the person knocking. His house was laid out in a fashion where this was difficult. And so the question the court had was, what is the test here? Is it that we're going to test Mr. Zora on what he actually could hear, or on the standard of the sort of objective, reasonable person, which would be somebody who puts themselves into a situation where they could always hear this, either because they've installed some better doorbell or moved their bedroom, if necessary, possibly sleeping right in front of the door. So that was the question, because if Mr. Zora's testimony was believed, his evidence would acquit him on a subjective mens rea standard. Unfortunately, it would convict him on an objective mens rea standard. So it became very important for the court to determine which test to apply. Now, at the appeals level, they determined that it was objective mens rea, but it went up to the Supreme Court. So what this how the Supreme Court ended up dealing with it, and I'll hopefully bring up the legislation here. So they noted that the absence of express words indicating subjective intent cannot on its own displace the presumption of subjective mens rea. What the court means by that is that unless there's something else that shows us that it should be an objective mens rea test, subjective is the presumed test. But they note furthermore, nothing establishes a clear intention to create a duty-based offense which calls for an objective mens rea. Duty-based offenses are directed at legal duties very different from the obligation to comply with the conditions of a judicial order. And, unlike these duty-based offenses, bail conditions do not impose a minimum uniform standard of conduct having regard to societal interests rather than personal standards of conduct. Parliament legislated a bail system based upon an individualized process, and the bail order is expected to list personalized and precise standards of behavior. So what they mean by that is because bail conditions are imposed on each individual person as an individual, they're not a general standard, that we can't really find that this is a duty-based offense that would require objective mens rea because the test is narrowly tailored to each individual person. The court also relies on the fact that a person who's convicted of a breach or even charged with a breach faces pretty significant consequences. Breaches are one of the key things that can lead to denial of bail in future. So if you think of somebody who's facing a theft of a car charge, for instance, they've been accused of stealing a vehicle and now they're before the court looking for bail. The court is going to look and see, is this person on release? And if they are, have they been accused of a number of breaches thus far? If so, they're a lot less likely to get bail. But further, if you have a record with a whole bunch of convictions for breach of bail conditions, you're a lot poorer off in terms of getting bail because the court is going to see you as somebody who habitually or commonly breaks their bail conditions. And that means that you're more of a risk to the public, you're more of a risk to reoffend. So we see that here in terms of a subjective fault requirement is consistent with the penalties and consequences which flow from conviction under 145 sub 3. That's the breach section, or one of them. A conviction has profound implications for the liberty interests of the offender, including imprisonment, even if the offender is acquitted of the underlying charge or further conditions imposed as part of a sentence. So what that means is, for instance, you could be accused of stealing a vehicle and put on conditions that might vary, and you might later be acquitted of having stolen that vehicle. It might turn out that was your car, or that you had permission to borrow it, or whatever else. But you might, in that intervening period, have been charged with a number of breaches, and you could be convicted on those breaches. And you could end up, sometimes people do more jail time on the breaches than they do on the actual charges. So that's what they're referring to here. A conviction under 145.3 creates or adds to that person's criminal record. Being charged under 145.3 also places a reverse onus on accused persons to show why they should be released on bail again. So what they mean here is that normally when you come before the court, unless you're charged with certain types of offenses, normally it's on the Crown to show that you should be detained. The presumption is that you should be released. Now, what happens is if you're coming before the court with a breach, it actually flips around. You need to show that you should be released rather than them having to show that you should be detained. So it becomes a lot more likely that you get held in custody if you're there on a breach than it did when you came in without any charges before. So previous convictions under 145.3 inform bail hearings for future offenses and may lead to the denial of bail or more stringent bail conditions for future unrelated offenses. Breach charges often accumulate quickly, leading to a vicious cycle of increasingly numerous and onerous conditions, more breach conditions, and eventually pretrial detention. So an example of this is you may have somebody who drank alcohol, got drunk, and committed some offense, and they get put on conditions requiring them not to drink. But a lot of people have trouble with those conditions. And so they're found drinking. And they might not have been found drinking and doing anything, but just drinking enough once they're on that condition that says that they are not supposed to. They get breached. And often on that new breach, they impose a condition that says, don't drink. And so let's say they get found drinking again. And this is probably because there's some alcoholism issues. Now they're being charged with a breach on their first release and a breach on their second release. So we can get this snowballing effect that can really ensnare people. So that's what they're talking about here when they say these charges often accumulate quickly. It's a circumstance where people can really get into a rough spot. Bail is one of the more important steps in the whole criminal process, and that's often because once somebody gets detained, they become a lot more likely to plead guilty. If you've been sitting in jail and you've been accused of something like a minor mischief, somebody says you broke their car window or something like that, if you're out on release, you might be willing to fight this. Particularly, you may have a good case. They just saw it, they looked out the window, they saw somebody breaking their window. They think it's you, but it was dark, it was far away, and you were somewhere else. But you might be willing to plead out to that just to get out of jail. It happens a lot, it's unfortunate, but that's one of the risks of detention here. Another argument that was made for an objective standard was that the conditions are tailored. You see this, they argue that bail conditions set at the beginning of bail process are carefully tailored to the accused and would lead to only minimal criminal liability for the accused. And skipping ahead a little bit, in other words, concerns about the treatment of marginalized individuals are factored into the conditions themselves, which obviates the need for a subjective fault standard if those conditions are breached. So essentially they were saying that subjective fault would provide some protection, but we don't need that for accused people because instead there's going to be consideration when these conditions are imposed. However, this is where we get into why this is such an interesting case, because the court essentially seems to be using this case as a lever to really complain or to intervene with what's going on with bail. Now, this started with a previous decision. It's the Queen and Antic. And in that decision, they essentially reiterated or tried to hammer home that people are to be released under the least restrictive form of release and with the fewest and least restrictive conditions possible. Zora really suggests that the court is upset that this hasn't been followed. And so we can see that here in paragraph 76. They note, many interveners described how, despite the fact that the default form of release should be an undertaking without conditions, studies across the country have shown that the majority of bail orders include numerous conditions of release, which often do not clearly address an individual accused's risk in relation to failing to attend their court date, public safety, or confidence in the administration of justice. So what they're referring to here is that there's three grounds for detaining people in custody. The first ground is that they're worried that you might not show up for court. And typically that's either because you have massive resources that would allow you to flee the jurisdiction, or because the offense is very serious and you might want to flee in order to avoid consequences, or you might have ties to some other place or minimal ties to Canada. So you might, for instance, be a foreign national or even ties to another jurisdiction. So you might be charged in British Columbia, but you normally live in Quebec. And so they might be worried that you're just going to go back to Quebec and try to avoid charges. Or you might have a lengthy history of not showing up for court dates. So these are all sorts of things that might suggest that there's an issue or a concern here in terms of your likelihood of attending court. The next one is public safety, which is that you're going to commit further offenses. And especially for this, if you're going to commit further offenses that harm or endanger the public. So they're going to weigh violent offenses here more heavily than they might property offenses. But even property offenses, you can get detained if they think that you're a prolific car thief and that if released, you're probably going to go out and steal another car. And the last one is confidence in the administration of justice. And so what that means is, essentially, is the public going to be up in arms? And for this, they don't consider the actual public. They consider sort of a reasonably informed public who is mindful of legal principles. So there are some differences between that and the actual public, but that's sort of how the court considers this. So would the public be shocked by this? So if we consider somebody who's accused of sexual offenses and is released and commits new sexual offenses, the public might be pretty shocked if they get another chance, if they get released again. So that can be itself a ground for detention. And there's various sub-considerations on that, like the strength of the Crown's case, as well as the severity of the expected punishment. So without getting too much into it, that's sort of the grounds for detention and what bail conditions have to be aimed towards. So the Supreme Court, in fact, goes on to express its further displeasure. We see here, several factors contribute to the imposition of numerous and onerous bail conditions. Courts and commentators have consistently described a culture of risk aversion that contributes to courts applying excessive conditions. So what that means is that if you have a judge who's considering release for somebody, one of the things that's always in the back of their mind is what happens if this person commits another offense. And similarly, a Crown prosecutor is thinking, what happens in the worst case scenario? So they want to sort of cover their own butts. And so part of the way they do that is by adding a bunch of conditions and by making the release perhaps more stringent than it needs to be. So that's what the court is referring to with this culture of risk aversion. Now they note as well, the culture of risk aversion must be tempered by the constitutional principles that animate the right to reasonable bail. So what the court is saying is that's not what the Constitution says. Constitution says you also need to consider this principle of restraint for the least onerous conditions. And we also see that they talk about, they say, as this court has recognized, the timing and speed of bail hearings impacts accused persons by making it difficult to find counsel, resulting in many accused who are self-represented or reliant on duty counsel who are given little time to prepare. This process encourages accused persons to agree to onerous terms of release rather than run the risk of detention both before and after a contested bail hearing. So what the court is referring to here is that people often find themselves in a situation where they might be representing themselves at a bail hearing, or they might not have the lawyer of their choice, and what they're told is you can be released now on these particular terms. And these might not be terms that are all that great for them. They might be fairly restrictive terms. They might be terms that cause them a big problem. So, for instance, you might have somebody who's told that they're not allowed tools that could be used to break into something. But it turns out that they actually do demolition work. So all of their tools are tools that you could use to break into something. They quite commonly have screwdrivers, crowbars, this kind of thing. But faced with the choice between staying in jail for even another night and getting out right away, they might say, yeah, I'll agree to that. And they might be thinking, well, I can fix this later, and sometimes that can be hard. Or they might just be thinking, well, we'll just have to... Sometimes people just agree to conditions that they know they can't follow and hope it works out for the best. And as a spoiler, it rarely does. Court goes on and notes, a third reality of bail is that onerous conditions disproportionately impact vulnerable and marginalized populations. And so they reference a case here called Omiyasu, and this is a case from Alberta. And what that case was referring to was it was a very simple principle. It essentially said we probably shouldn't be imposing conditions to abstain from alcohol or drugs on people who are addicts, because we know that they're unlikely to be successful, and we're simply setting them up to fail. So we'll see here, they emphasize that, and they say Canadian bail courts regularly impose abstinence requirements on those addicted to alcohol or drugs, residency conditions on the homeless, strict check-in requirements in difficult-to-access locations, no contact conditions between family members, and rigid curfews that interfere with employment and daily life. Numerous and restrictive conditions imposed for considerable periods of time are setting people up to fail, and failing to comply with a bail condition is a criminal offense, even if the underlying behavior is not otherwise a crime. And that's quite common. If you have somebody who's required to report to a bail supervisor, normally the average person who isn't facing charges doesn't have to report to a bail supervisor. And this can be a pretty substantial requirement. If you live out in the bush and you have to go into town every week, that could get expensive, especially if you don't have a car and you might have to pay other people to drive you. Often these conditions can be very difficult for people who are trying to hold down a day job. Because if you think, you're working construction, one of the big things your employer is going to want from you is reliability. And if you're not reliable, eventually they're going to find somebody who is. And if one day out of the week, every week, you need to take some unspecified amount of time off because you've got to go check in with a bail supervisor, they may not be too keen on having you around. That may not be you're not going to be their favorite worker. So these kinds of conditions, each condition creates more and more obligation on people. The other example they give is residency conditions on the homeless. Telling somebody that they have to reside at a particular address, that's all well and good. But if you've got somebody who's homeless, we're not just magically creating a house for them just because we put a condition on this. So the court notes the presence of too many unnecessary conditions and the prevalence of breach charges resulting from the imposition of excessive and onerous conditions is part of the legislative context in interpreting Section 145 sub 3. So what this means is that part of their decision for why to go with a subjective mens rea standard rather than an objective mens rea standard is that they really don't like what's happened in the courts in terms of these conditions being imposed unnecessarily and excessively. So if you wanted to go sort of a certain distance, you could say that they've actually changed the test or chosen one test over the other as kind of a punishment for the fact that their previous ruling in Antic, which really said that conditions need to be least restrictive, wasn't being followed. Because they've said that bail is regularly being imposed in a fashion that, in their view, is not lawful or not consistent with what the law requires, that's one of the reasons why they went with a subjective rather than an objective test. Skipping ahead a little bit, we see that the court actually spends substantial time discussing the general principles governing bail conditions. And so what that means is that the Supreme Court is essentially taking a lot of time to discuss something that is outside the core issue of this case. And where the court does that, it's technically not binding. However, I would caution the Supreme Court doesn't speak lightly. And so where the Supreme Court does something like this and essentially provides this sort of guidance, it should be taken as very meaningful. Lower courts should and will take this very seriously. So one of the things they note here is that conditions have to target the specific risks. And what that means is that they have to target either your failure or your likelihood of missing court, your likelihood of committing further offenses, or the general ground of putting the administration of justice into disrepute or shaking the public confidence. So they note if an accused is a flight risk but poses no other risks, only those conditions that minimize their risk of absconding should be imposed. So we shouldn't just start tacking on other conditions to minimize their risk of reoffending if that's not a substantial risk here, just because they might be a good idea. So, and they also say if an accused poses a risk to public safety and protection, only the least onerous conditions to address that specific threat should be imposed. So this is a very restrictive test. And the reason why they're restrictive here is because somebody who's on bail is presumed innocent of the charges. This is somebody who, and ultimately if you're acquitted, you can't sort of get that time back that you've been under restriction. And if these conditions have blown up your life, you're not going to have a whole lot of remedy for that. So that suggests that we should really be cautious in terms of how much we restrict people's lives and how much we create the risk of potentially throwing them in jail over just breaches of these conditions, given that somebody may ultimately be acquitted of the underlying charge. So the way they do this is they establish or reiterate, because it's not really established in this case, it was established in previous decisions, but they reiterate the requirement of necessity. And so they describe that as The requirement of necessity also means that the particular condition must attenuate risks that would otherwise prevent the accused release without that condition. So essentially, if an accused person is releasable without that condition, then they should be released without that condition. They also note that conditions cannot be imposed for gratuitous, so unnecessary, or punitive purposes. And the reason why you can't have punitive conditions is, again, somebody hasn't been convicted. You can't punish them for a thing they're presumed innocent of. So they distinguish between probation orders here. A condition that may be suitable for a sentencing purpose, like rehabilitation, will not be appropriate unless it is directed towards the risks in section 515 sub 10. So that's the provisions that talk about how you can detain somebody. Conditions should not be behaviorally based, and a condition that merely seems good to have but is not necessary for the accused's release is not appropriate. Even if some condition is thought to be therapeutic, intended to help, or couldn't hurt, the prospect of additional criminal liability under section 145.3 means any such limits on otherwise lawful behavior may also attract criminal penalties. So you can't impose a condition for the benefit of the accused. So you might think that you're helping them out, but you still can't do it. That's a big deal here. It really is intended to limit how much these conditions are imposed. They also implement another test, which is that bail conditions don't just have to be necessary, but they also have to be reasonable. And one of the considerations for reasonability is that bail conditions cannot contravene federal or provincial legislation or the charter. So there's a common example, and we'll get to it because the Supreme Court discusses it specifically, and they're referencing it here where they mention the Shoker decision. But in some cases, they might be tempted to impose a condition that requires that you consent to a search of your house, for example. And so the court here is essentially saying that can't be imposed because it's not reasonable, because it contravenes federal or provincial legislation or the charter. In this case, that would be a breach of the charter. So reasonable conditions must also not limit the charter rights of an accused, such as their freedom of expression or association, unless that condition is reasonably connected and necessary to address the accused's risk of absconding, harming public safety, or causing loss of confidence in the administration of justice. So they're not saying that can't ever happen, but it can only happen in narrow circumstances where it's necessary in order to address the concerns here. They also note bail conditions are to be tailored to the individual risks posed by the accused. There should not be a list of conditions inserted by rote. The only bail condition that should be routinely added is the condition to attend court, as well as those conditions that must be considered for certain offenses. And as an example, for domestic violence and so forth, they have to consider whether or not to put a restriction on firearms. There's no problem with referring to checklists to canvass available conditions, but the problem arises if conditions are simply added not because they're strictly necessary, but merely out of habit, because the accused agreed to it, or because some behavior modification is viewed as desirable. Bail conditions may be easy to list, but hard to live. What they mean by checklists here is that often courts will have a sort of listing of predefined conditions. And those conditions are ones that have sort of been pre-drafted, and the language has been worked out because you want to get the language right. You know, what exactly do you want to include as exceptions, for instance, to a weapons clause? If we're saying somebody can't have weapons, how do we define that? Are there, when are we going to add exceptions? So if we say somebody can't have knives, a very common exception is knives used for preparing or eating food. We want to accept so that you're not going to get breached if you happen to have a kitchen knife or the like, because of course you have to have those things, or almost all people do. But the problem that can happen is once you've got this checklist, it can be really easy to go down this list and just start ticking all the boxes that seem like they're connected. And so the Supreme Court is really saying that behavior is not appropriate and should not be followed. If we skip ahead a little bit, we can see where the court now starts to get into specific conditions that they essentially have a problem with. They say, these are appearing in a lot of bail orders and we don't like them. You need to stop. You need to change what you're doing. So this is the Supreme Court issuing some very specific directives as to how bail should work. So we see at paragraph 92, first, judicial officials should be wary of conditions that may be directed towards symptoms of mental illness, which they specifically include as drug and alcohol abstinence conditions for people with actual addictions there. So they say if somebody can't abide by a condition, then it can't be reasonable. And they also note, in addition, rehabilitating or treating an accused addiction or other illness is not an appropriate purpose for a bail condition. A condition will only be appropriate if it is necessary to address the accused's specific risks. Subjecting individuals who are presumed innocent to abstention conditions may effectively punish them for what are recognized health concerns. And they also note, if that individual is suffering from an alcohol addiction, an absolute abstention may present substantial risk to the health and well-being of that person and even give rise to potentially lethal withdrawal effects. So what they're referring to there is that alcohol is one of the drugs, and this doesn't apply to all drugs, but some drugs can actually kill you if you stop taking them abruptly. Alcohol is one of them. So in some cases, telling somebody that they have to stop drinking right away, actually complying with that could kill them. We don't have the death penalty at the bail stage. We don't have the death penalty at all, but if we were going to have it, it certainly wouldn't be at the bail stage. Now, they go on. They say, if an abstinence condition is necessary, the condition must be fine-tuned to target the actual risk to public safety. For example, by prohibiting the accused from drinking alcohol outside of their home if the alleged offense occurred while they were drunk outside of their house. And so what they're saying is you have to narrow this down. You may have somebody who can't stop drinking, but we might be able to sort of tailor how and when they drink. And that's going to be a process that requires some consideration of this individual as an individual and what their particular circumstances are. So they also note here, other behavioral conditions that are intended to rehabilitate or help an accused person will not be appropriate unless the conditions are necessary to address the risks posed by accused. So where you typically see this is young offenders, because very commonly they'll impose conditions on young offenders to require them to attend school. Other people get conditions of attend counseling or treatment. Quite commonly, although it's fallen off in recent years, people used to be directed to attend work. So, you must seek and maintain employment. So you have to have a job and you have to go there and so forth. But this is a problem here. You can't try to improve someone's life, even if we recognize that often people being in sort of bad situations, being unemployed and so forth, may be something of a risk, but it has to be very narrowly tailored. So it has to be something where the person isn't going to be releasable unless they do these things. And they also note the issue here is a condition of whether the condition is proportional. So they note that somebody could be convicted of a criminal offense for skipping school. We also see sometimes they impose follow the rules of the household conditions on young people. So, 15-year-old who's accused of something, they put them on conditions that say, essentially, do what your parents tell you. But that means that this kid could potentially be charged with an offense and could go to jail for not doing the dishes. That doesn't make a whole lot of sense to me. They also describe the condition of keep the peace and be of good behavior. And what that condition means, essentially, is don't commit any further criminal offenses. So this is a required condition for probation order CSOs, which are sort of house arrest, where you're sentenced to jail, but you serve that jail in the community, and peace bonds, but it's not a required condition for bail. And they say it should be rigorously reviewed when proposed as a condition of bail. So what that means is that they say that if the judge or justice of the peace has this condition proposed to them, they should ask if this is really necessary. So there's noting that it adds a new layer of sanction, not just to criminal behavior, but from everything from violation of speed limit regulations and dog leashing bylaws of a municipality. So essentially, it covers everything. And what that means is, as well, for any breach, if you have a breach of, say, a no alcohol condition, and to keep the peace and be of good behavior, if you breach, they're going to hit you with 2 charges, not just 1. So it effectively doubles things up as well. They also, as mentioned, specifically talk about the rules of the house or follow the lawful instructions of staff at a residence. And again, that when you get that condition, we don't know what that means, because the rules of the household aren't going to be before the court, and the lawful instructions of staff at a residence aren't going to be before the court. So the judicial official isn't going to be able to assess the proper validity of that condition at the time they impose it. And similarly, the accused isn't going to know what they are agreeing to. And this gets especially bad when we consider that young people are often living in houses that are maybe not the best. Maybe their parents are involved in criminal activity themselves. How are we supposed to consider it if the rules of the household end up including, and you're going to help me break into houses? Are they going to get breached for that? Especially if you're talking about somebody who's, a young, vulnerable person, they're going to be in a situation where how do they decide which to do? And they also talk about how this delegates the creation of bail rules to a third party. And that's a problem because there's a principle that says that effectively the court can't delegate certain powers. They can't give away certain authority. So the court is specifically saying these conditions are a problem. They also warn about perverse consequences or unintended negative impacts. And as an example, and I'm not going to give enough details that you could track things down here or anything like that, but I had a client on a no alcohol condition. And they called me to indicate that they had become aware of criminal activity and they wished to report it to the police. But because they became aware of this during a time when they were in breach of their conditions, they were drinking, the concern becomes, how do they report that without going to jail? And ultimately that was worked out. Of course, I'm not giving any details here because they've got there's confidentiality, there's privilege. So this is a very general thing. But you might have somebody who, for instance, is drinking in breach of their conditions and gets attacked. And now they don't know whether they should call an ambulance, call the police. What do you do there? So this is actually an example from a case, because the big case on don't impose no alcohol conditions on alcoholics, which is omiyasu, was a situation where the person who was charged was the victim of a domestic assault. And she was charged after she called police for help. So I've got problems with what happened in that case, and the judge had problems with what happened in that case. And we can see here there's a little bit of sort of judicial side-eye where they say, while one hopes that prosecutorial discretion would help prevent these types of unintended consequences, such conditions may prevent a disincentive to reporting serious crime and significantly increase the vulnerability of certain people. So there's a little bit of judicial side-eye because prosecutorial discretion, for instance, didn't protect Miss Omiyasu. They give some examples of this. So red zone conditions, which are conditions that blank people out from going into certain areas, and this is sometimes imposed, for instance, in high crime areas. You might bar somebody from going to the downtown east side, or areas where drug activity is known, or where drug dealing is known to occur. And no drug paraphernalia conditions. So paraphernalia prohibitions, they note, if you're not able to carry around needles that are clean, and that, or at least if they're not clean, that you're just using yourself, you might end up borrowing needles from someone else, and thus increasing your risk in the spread of disease. And similarly, these conditions where we block people out of areas, often these are also the areas where services are offered. So we might block somebody out of the areas where drug treatment is offered, where there are homeless shelters. Sometimes I've seen conditions that block people out of going to the hospitals. And so that creates issues. So that's what the court is talking about here. These are a number of conditions that the court is very much saying that they don't approve of and that they've been overused. There may be a place for them, but that they should be essentially ratcheted back or restricted. They also note a particular example, and they say that some bail conditions may impact additional charter rights of the accused beyond the right to be presumed innocent, liberty rights, and right to reasonable bail. And they say that principles of restraint and review require that judicial officials rigorously examine these conditions and determine whether they do infringe the charter. And in particular, they mention search conditions. And they note, as noted by this court in Shoker, which is another Supreme Court decision, in the context of probation conditions, a judge does not have jurisdiction to impose a condition that subjects an accused to a lower standard for a search than would otherwise be required unless Parliament creates a charter-compliant statutory scheme for the search or the accused consents to the search. So what that means is that they can't put these conditions that facilitate the gathering of evidence, to quote the Supreme Court here. And so you'll see conditions where the police are allowed to search somebody's home or their car or sometimes their person. Perhaps their phone is allowed to be searched. And so the Supreme Court is saying that's not proper. What should happen is that if the police have a suspicion that something is going on, that the police get a warrant, and just as they would for anyone else. They also note that there are sometimes conditions that affect an accused's freedom of expression or freedom of association. So if you put somebody on a condition not to use the internet, that can substantially impact their freedom of expression. Right now, I'm here communicating ideas and information to you. I'm exercising my freedom of expression. This would not be possible if I was barred from the internet. And if you have conditions, for instance, sometimes I've seen conditions that somebody not go to protests. Well, a protest is obviously somebody's freedom of expression. And so unless there's some reason why they absolutely need to be forbidden from that, the court shouldn't impose that. The court goes on to talk about responsibilities. And this is really where they start calling out different participants in the justice system. They note all persons involved in the bail system are required to act with restraint and to carefully review what bail conditions they either propose or impose. And they talk about that in terms of the conditions or the principles that were already set out. But they note that this is an individualized process and there is no place for standard, routine, or boilerplate conditions, whether the bail is contested or the product of consent. They note that the Crown, defense, and the court all have obligations to respect the principles of restraint. And they also note that the Crown should understand and, if asked, be able to explain why proposed bail conditions are necessary, reasonable, least onerous, and sufficiently linked to the risks. And they call this a prosecutorial responsibility, not just a good idea, but a thing they have to do. They point out that it's in the manuals that were, like the policy manuals that were put to them. So they think that that's effectively something the Crown already should know, but they re-emphasize that. But they also go on to call out, and I don't think this is improper, although it is a little unusual. They talk about defense counsel should also be alive to bail conditions that are not minimal, necessary, reasonable, least onerous, and sufficiently linked to an accused's risks for both contested and consent release, especially when a client may simply be prepared to agree to excessive and overbroad conditions to gain release. So what this means is that defense counsel have an ethical obligation here to consider whether this condition is something that has to be fought because it might not be lawful pursuant to these rules. Now they go on, they recognize here that sometimes it's a hard job being a defense lawyer because they say, that said, it is not uncommon for counsel to agree to a condition that may seem somewhat onerous, but does not warrant turning the matter into a contested hearing, which could result in the accused having to stay in custody for a few more days. In such cases, counsel can also seek a review of the condition after a reasonable length of time and ask that it be altered. So if you have a client who's facing jail facing a condition, and that condition might not be proper, but the only other way that can be heard as a contested hearing might be a scheduled hearing sometime down the road. So what the court here is saying is that it is okay if defense counsel say, okay, we'll agree to this now, and then schedule a review hearing for that to say, now after the client's been out, we can go and fight over that condition. So, but ultimately, they say, the obligation to ensure that accused persons are released on appropriate bail orders lies with the judicial official. And that makes sense, right? That's the person who has the power. That's the person who sits in the big chair. That's the person who wears the fancy robes. That's the person who makes the calls. They control the process. So as with the setting of cash deposits in Antic, the previous decision I've mentioned, if a judicial official does not understand how a condition is appropriate, they're under a positive obligation. That means is they have to step forward, they have to take these actions to make inquiries into whether the suspect bail condition is necessary, reasonable. I've gone through that several times. So before transforming bail conditions into personal sources of potential criminal liability, they're asked to use their discretion with care and review the proposed conditions to make sure they're focused, narrow, and tightly framed to address the accused's risks. So they also note that they can and should question conditions that seem unusual or excessive, and they should be alert for any pattern that might suggest that conditions are being imposed routinely or unduly. So they don't just have to look at the hearing that they're in, but they also have to look at the hearings that have been taking place over the course of the day, over the course of the week, over the course of the months, and see if they see a pattern where something is always being asked for. Because the court here has said there's no place for boilerplate routine conditions. So if that's happening, the judicial official may have to step in. They also note that these obligations carry over to consent releases. However, and this is because, again, you might accept conditions just because you want to get out. However, there are some practical considerations here. A consent release, it's supposed to be a fairly straightforward, streamlined, rapid process. So the degree to which the judicial official may necessarily be able to make inquiries is going to be limited to that. But they do note that these factors, and they're referring to people sort of accepting take it or leave it conditions, have contributed to a culture of consent in which accused persons, who often represent themselves at bail hearings, frequently agree to be bound by conditions which are unnecessary, unreasonable, and even potentially unconstitutional. So that makes sense. If you've got somebody who's in custody and is being told, I'll agree to your bail if you agree to these conditions, but otherwise I'm going to try to keep you in custody, they're going to agree. It doesn't really matter what those conditions are. They're pretty much always going to agree. So we have the court talking about, although courts are busy places where consent releases can encourage efficiency, little efficiency is achieved if an accused person is released on conditions by which they cannot realistically abide and which will inevitably lead to greater use of court time and resources. So what they're saying is, by front-loading the work, if you do the work early, you're going to have less work to do later. But we can see here that this is a huge directive to everyone in the justice system. Not just to Crown, not just to defense, not just to judicial officials. Everybody is required. They're essentially trying to lay down the law here and say, we don't like what we've been seeing. We don't want it to continue. Stop it. Do something different. Here's the law. It's a bit of an incredible decision. We don't often see this kind of directive from the court. And I would suggest that this suggests a strong degree of displeasure that the court has been made aware of something that they're very unhappy with. And so in Antic, they set the early stages of this. The Zora decision is really an indication that they're unhappy that what they set down in Antic hasn't been followed, that things didn't change as much as they wanted. And I suspect that if things don't change as much as they want as a result of the Zora decision, we may see a further decision down the road where the Supreme Court comes back with even stronger language. And I don't know what that would look like. I can only vaguely conjecture. But it's very clear that the Supreme Court is very unhappy about what's happened here and is trying to take active steps and with strong language to try to correct that. Thank you for watching. I hope this has been informative. It's a little longer than I would like, but we're talking about an 87-page decision. I hope I've managed to summarize it in a way that's been useful. If it has, please like, share, and subscribe. And please feel free to leave in the comments if there's any questions you have, anything in the law that you'd like to know more about, or perhaps something that you've seen in the news. I make these videos because I enjoy teaching. I enjoy sharing information. I think it's important that people in the legal profession share their information, including with the public, because the law is a dense and often difficult thing. I've been a teacher at different points in my life. I quite enjoy it. So that's one of the things that brings me to make these videos, to post things to my Facebook page. Again, I hope you've enjoyed this video. I hope you found it informative, and I hope you keep watching. Thank you.